This is V for Verdict, a podcast where we discuss Kenyan cases and the stories behind them and how they influence your life. Now, one of the key questions that often comes up in matters of employee discipline is that can an employee be punished twice for the same offense? So, for instance, can you discipline them for misconduct and then proceed to terminate them for the same offense? Now, luckily for us, this matter came up in court before the Employment and Labor Relations Court in the matter of Mboya versus Mini Bakeries Limited, 2022 matter that was decided in 2023. Now, the brief facts of the case are that Mr. Mboya, who was a claimant, was initially employed as a charge hand baker in 2016, and over the years he rose to the position of manager, at which point he was earning a gross salary of about 109,000 shillings. Now, in September 2021, he was transferred by his employer to Bungoma as a branch manager. And according to him, in Bungoma, he encountered an unethical environment where integrity was ignored by his co-workers. It was his observation that supervisors often solicited bribes before hiring casuals, and casual workers were hired based on personal connections, and supervisors allowed employees to go home with bread every day in exchange for some money. Also, he stated that the bags of unga that were supplied were often underweight. Now, it was his evidence that he reported this malpractice to his immediate boss, who was the assistant operations manager, but no action was taken. So he liaised with the watchman at the gate to undertake a search of employees before they left. Now, this led to the discovery of bread being taken home. When his supervisors heard that he was questioning the issue of workers living with bread, it was his evidence that they sabotaged him by allowing more bread to be taken by employees and promised to frustrate him. One of the supervisors allegedly even called the regional office to discredit his claims. Now, in November 2021, the employer conducted a stock audit that uncovered a shortfall of bread worth 95,000 shillings. Now, when Mr. Mboya was put on his defense, he attributed the shortfall to sabotage and that bread was being handed out to the casuals. He maintained that the shortfall was stage managed by his supervisors and other senior managers who did not like his management style of dealing with malpractice. He stated that the issue was referred to the security personnel for investigation, and they confirmed that one loaf of bread was given to each employee after work. He was then summoned to the regional office in Kisumu, and a recommendation was issued that all employees at the Bungoma branch would pay the shortfall. He said this recommendation was frustrated and the shortfall was unfairly pinned on him. He also argued that the security investigation report that was forwarded to the disciplinary committee, and he was invited to a disciplinary hearing on 9th of December 2021. It was his argument that this report was never availed to him. Now, after that hearing, a decision was communicated to him on the 15th of December, about 6 days later, recommending that the shortfall be shared between him and the assistant operations manager. He then executed a deduction form where he was deducted 47,507 shillings, and according to him, he believed that the matter was finally settled. Now, while he was on approved leave, he was summoned and given a summary dismissal letter that was dated 21st September 2021. This was about 6 days after the decision was issued, indicating that he and the operations manager would share the shortfall. Now, that letter of 21st December cited the disciplinary committee's recommendation as too lenient, and he was therefore summarily dismissed. His argument in court was that his dismissal was unfair, it did not consider witness evidence, and it violated the employer's human resource policy. So, of course, when we talk about employment matters and how to go about dealing with misconduct, there are two key things that we always advise. The first one is that the employer has to be able to show that there were sufficient reasons to cause them to take disciplinary action against the employee. So these are the facts that the employer believed at the time to exist. The second thing is that the employer is also required to show that he followed the proper procedure in carrying out the dismissal. Now, in court, the employer's case was that Mboya was accused of laxity at work over the manner he was conducting his operations. According to them, he did not curb the vices he alleged were in his station when he was in charge of the casuals, and it had also been proved that he was engaged in the same vices, which then led to disciplinary action being taken against him and their subsequent dismissal. Now, the employer said that Mboya's position obligated him to report the vices he witnessed to the proper authorities, but he failed or neglected to take any action. They stated that due to the persistent theft, he was issued with a show cause letter on 1st December 2021. The investigations carried out were based on evidence of losses and not as a setup as he had alleged, and they were lawful and binding on him. On 9th December, the disciplinary finding established that Mboya was dishonest as a branch manager and his subordinates had lost their faith and trust in him, which led to the dismissal notice of 15th December 2021. The employer also submitted that Mr. Mboya, in terms of process, he was given sufficient notice in writing in a language he understood, and he was accorded all the necessary principles of natural justice. And of course, when you talk about natural justice, what you're basically saying is that you have a right to be informed what the charges are against you. You have a right to be given an opportunity to give a response, and that response needs to be considered before a decision can be made. Now, further, after the disciplinary action, the employer stated that Mboya was not remorseful, and he continued to engage in the gross acts of negligence and malpractice, and therefore he was dismissed on 21st December 2021, which, in their opinion, was justifiable. So clearly, one of the questions that the court has to contend with immediately is on reasons. Were there proper reasons here? Of course, according to Mboya, he said that there was no reason for his dismissal because the only reason available was the one that was put before the panel, before which he appeared, he was heard, and a decision for cost recovery was made. He was not terminated. Now, the employer's charges citing continued engagement in gross acts of negligence and malpractice, they lacked specific instances or clear evidence of wrongdoing on his part, which is a requirement under Section 45(2) of the Employment Act. Mboya stated that his dismissal was orchestrated by senior officials with whom he had disagreements, and that he had reported all malpractices in his station to his immediate boss, who was the assistant operations manager, and the investigations did not find him culpable. According to him, the final warning letter was not served upon him, therefore violating the HR policy. So for him, the employer was not conducting this matter in line with the HR policy of the organization. Now, under the organization's HR policy, a final warning letter must precede any termination action. So the committee's decision was communicated on 17th December 2021, and this involved recovery of the cost, followed by the dismissal letter on 21st December 2021. He claimed that there was procedural unfairness, stating that 2 decisions were made against him within a short time frame. And he insisted that he should have been invited to a new hearing for the alleged gross acts of negligence that were mentioned. Now, when the employer brought their witness, the witness argued that Mr. Mboya had on prior occasions been warned and also submitted that due to his actions, they had lost a client. Referring to Section 44 of the Employment Act, the employer argued that Mboya's conduct breached the terms of the contract and therefore justified summary dismissal. His transfer to Bungoma revealed malpractices flagged by the regional manager, leading to an audit indicating a shortfall of 95,000 in polybags and bread, which was a suggestion that there was theft of company property ongoing. They stated that Mboya failed to prove the sabotage claim, and none of his witnesses proved that. On the issue of the warning notices, the employer stated that they printed 3 notices, with 2 issued to the employee to sign and return, and no notice could be in the employee file having not been issued. He submitted that employees could sometimes not return their signed notice, but the employees had access to their files and knew of any notices against them. The employer stated that only 1 decision was issued against Mboya, and this was the surcharge and the summary dismissal. Now, the summary dismissal was issued later than 7 days because the proceedings had been conducted in Bungoma, and it took longer to transmit documents to headquarters in Nairobi for the preparation of the dismissal letter by the overall manager. According to them, the dismissal letter did not introduce new grounds, but the same was based on the grounds of the show cause letter, and that therefore they were in compliance with Section 41 of the Employment Act, Article 51 and 47(1) of the Constitution of Kenya, and Mboya's claim that he was not heard was untenable. The employer's witness also submitted that Mboya was not discriminated against, as the assistant operations manager, his immediate supervisor, was also summarily dismissed. Now, the court first begins by noting that the lack of simultaneous communication was not justified. One of the claims here is that he had continued to engage in gross acts of negligence and malpractice after the disciplinary action, which caused a loss of trust among co-workers. However, no evidence of these infractions was presented to him or in court. It was the court's view that the decision for dismissal was made after another action had been taken against him within the allowed timelines as required by the HR policy. Now, the court was of the view that a reasonable employer could have rendered its decision either concurrently, which was to dismiss him and surcharge him at the same time, or surcharge him only. The action by the employer to issue punishment piecemeal was against its own operational requirements. Now, while the employer had stated that the delay in issuing the dismissal notice did not prejudice Mr. Mboya, the court found that this was untrue, because in the HR policy, he had reasonably expected that the surcharge could resolve his disciplinary proceedings within the stipulated 7 days. Now, the next thing the court had to look at was the summary dismissal. The court noted that the letter stated, and I read, the management considers action proposed as too lenient and has decided to summarily dismiss you. In the court's mind, this expression raised doubts about whether the disciplinary committee had made two recommendations, termination and surcharge. This doubt was founded because the proceedings were recorded but they were never availed to Mboya, at least at the point of the surcharge. So the court concluded that the employer's dismissal decision seemed like an afterthought after additional considerations had been made. Now, in the court's opinion, at the disciplinary hearing, there were justifiable reasons that could have led to the disciplinary action. The employer chose the path to recover costs. Later, and outside its own policy timelines, they then imposed another severe sanction of dismissal without justification. Consequently, the non-compliance with their own procedures under the HR manual and the issuance of two decisions at different times amounted to unfairness. Now, on procedural fairness, according to the employer's HR policy, an oral warning issued to an employee would be followed by a note confirming the oral warning had been given and placed in the employee's file. For written warnings which were for serious offenses, the employee would be notified in writing by their supervisor. Now, a written warning would lapse in 12 months but would be retained in the employee's file. After receiving the first and second warnings, if an employee did not change their conduct and received a third warning, which was a final warning, within 12 months, they would then be subjected to a disciplinary hearing and subsequently summary dismissal. However, the court was also of the opinion that the HR policy granted the employer the power to summarily dismiss an employee for gross, willful misconduct, even without the first, second, or final warning. So was the decision to summarily dismiss Mboya procedurally sound? Now, according to the disciplinary procedures for handling gross misconduct in the HR policy of the organizations, investigations will commence and a show cause letter would be issued to the employee. The employee was then to be given at least 3 days' notice before the disciplinary committee hearing, with the option to be accompanied by another employee. The tribunal's decision would be communicated to the employee within 7 days from the hearing date. The court emphasized that when an organization sets a specific procedure for handling disputes, then it must follow that procedure. First, the decision to terminate was made 12 days after the hearing instead of the 7 days provided for in the policy. The employer argued that this was due to the delayed forwarding of documents to headquarters, but the court relied on the rule which provides that in the case of a one-sided contract, such as an employment contract, the interpretation of documents should be interpreted unfavorably to the drafter, in this case the employer. So it's important to note that when it comes to employment contracts, since the bargaining power is with the employer and they are the stronger party, if there is a term that is not clear, the court will always interpret that in favor of the employee, all right? Or rather, unfavorably to the drafter, which is the employer. Therefore, the employer, having failed to issue the decision within its own timeline in the HR policy, could then not escape the consequences of non-compliance with the timelines that were set there. Now, the lesson here is that when a disciplinary committee recommends both surcharge and dismissal as a disciplinary penalty, both decisions should be communicated to the employee together. If that decision is made afterwards, then it requires a separate process for it because the employee has to be given a chance to make a representation. So this is important for employers to note that One, the law allows you to both surcharge and to dismiss an employee. But when you choose to go the surcharge route, you cannot then come back and say that you're going to terminate them after. All right. So in this case, the employee was awarded compensation for 6 months' salary and 2 months' notice pay. So this is an interesting decision because it highlights the court's approach to determining matters of procedural fairness in employment termination. Organizations have to meticulously adhere to the internal HR policies, which is important as well because you now need to look at your HR policies and see what are some of those provisions. Remember, when it comes to handling of employment matters and disputes, at the end of the day, what the court wants to know is that you followed the process. So any disciplinary issues touching on employees, you have to show a fidelity to the procedure that is set down under your own policies and also under the law. In this case as well, there was a requirement for timely communication and substantiating termination decisions with clear evidence. That's from us today. So to answer that question that we asked at the beginning, can you take an employee through two processes? All right. Can an employer discipline an employee for misconduct and then proceed to terminate them for the same offense? That can be done if it is being done simultaneously. However, if one is done and then the other follows days later, that amounts to unfair labor practice. This is V for verdict.